Welcome back, ladies and gentlemen. We will now begin our lunchtime chat on building your career as an arbitrator. I'm sure we've had really full lunch, so this should be like a coffee chat. The panelists for this chat are Mr. Manish Aggarwal, Ms. Sheila Ahuja, partner at Allen and Overy LLP, Dr. Michael Hwang, senior counsel, Mr. Nair, advocate and arbitrator at Arista Chambers, and moderating this discussion is very lovely, Ms. Nudra B. Majeed. Nudra, over to you.
Thank you very much, Shweta. Hello, everyone. Welcome back. Since we're all in different time zones, some of us actually have not had lunch, technically. But welcome to this lunchtime panel discussion on building your career as an arbitrator. I thought I would situate the panelists so that you all have a good idea where everyone is. I am zooming in from Lahore, Pakistan. And if you hear a cacophony of birds in the background, I just want you to know that I'm not sitting in an aviary, but it is the season of the year where birds are migrating from Siberia through Pakistan and India on their way south. So we have quite a full party going on outside. Our panelists are also sitting in different places. Manish Aggarwal is zooming in from London. Sheila Ahuja and Dr. Michael Hwang are in Singapore. And Sheila, if at any point we see her suddenly get into a taxi, it's because I understand that today she is actually moving into a new house. So good luck with that, Sheila. And then we have Nair from Bangalore. Unfortunately, our fifth panelist, Makhdoom Ali Khan, would have come in from Karachi, Pakistan, but he is down with flu. But fortunately, it's not COVID, so we wish him the best of luck. I'm honored to host this sterling panel of guests today. They are all stars in their field, and that is the thing that they all have in common. Although their trajectories into the world, the glamorous world of arbitration has been different, and we will find out about that, but they are all legal practitioners and they're all stars. So for the next hour, we have the happy task of getting to know what makes these stars shine. Now, I understand that majority of the participants this year are from India. So I have taken the liberty of borrowing a Bollywood formula from one of the famous directors, Karan Johar. And what I plan to do with this panel is for the first half of this segment, I'm going to throw a rapid fire round of questions so that we get the panelists to introduce themselves. And for the second half, it will then be open to questions. I welcome your questions. Do send them in the question and answer chat facility, and then I will be asking questions of various panelists. So we are going to blur the lines of age and experience, and we're going to hit this alphabetically, starting with Manish Aggarwal. Manish, rapid fire round. When were you first introduced to the world of, or let's say the word arbitration? Were you a student or were you in practice?
Thanks so much, Nudra. I think my first rendezvous with arbitration was in law school. And that was through my participation in the Wismoot in my second year. Yeah, I think that was the first time I kind of studied the subject.
Where were you? Which part of the world?
So, I studied law at the National Academy of Legal Studies and Research, NALSA, University of Law in Hyderabad.
I see.
So, it was.
And what drew you to arbitration?
So, I think in terms of my choice of arbitration as a career, I think my participation in the Wismoot was, of course, the introduction to the world of arbitration. But I think if I had to kind of pick one experience that really influenced my choice of arbitration as a career, I think it was my experience at the University of New South Wales as an exchange student in Sydney in 2007. And during that time, I got the opportunity to engage deeply with arbitration law. I did an LLM course with Professor August Reinesch, whom some of you may know is one of the leading commentators in and a leading light in the field of investment arbitration. And I think that came to influence my choice of career. Now, I actually wanted to pursue a career in in a field that gave me a constant intellectual challenge, allowed me to travel. Now that's of course in the pre-COVID world, and also I think above all, allowed me to do my own oral advocacy. For me, that was quite a big part of the choice of arbitration. And uh, I at the time in 2007, uh, a lot of the firms were recruiting directly from India, and I interviewed with Alan and Overy. So Sheila and I are former colleagues, and I was interviewed by somebody in the litigation department uh, who was not that perturbed by the fact that all my internships had all been in litigation and arbitration. I hadn't done a single internship in any transactional area, and I think they were quite interested in the fact that I was very interested in doing my own oral advocacy and pursuing a career in arbitration, and that then kind of led me to London in 2008. Unfortunately, at the time, India was still reeling from Bhatia and its progeny, the two infamous cases that had made India quite an unattractive destination for anybody to even practice arbitration. Uh, and I didn't really see much scope to pursue a career in India at that time. Things, of course, today are radically different, as we know.
Very interesting. And so then you moved to London. I understand you moved from Allen and Overy. You then moved to Three Crowns. And Three Crowns, they specialize purely in arbitration?
That is correct. As a firm, we don't practice any other area of law. Arbitration is what we do, and that's all we do.
So when did you get your first appointment as an arbitrator?
My first appointment was in 2019. It was an institutional appointment as a sole arbitrator uh, by SIAC. So I think it's the right forum to be talking about it.
All right, now a little personal. What made you confident that you felt that yes, I can be an arbitrator now? What were you most confident about in yourself in terms of the skills you had?
So by the time I got my first arbitral appointment, I'd been practicing arbitration and arbitration alone for a decade as counsel. And I had also had an opportunity to sit as a tribunal secretary as a junior associate. So I think that kind of gave me an insight into the process. And having worked as counsel means that you have the requisite experience of project and case management. You've kind of seen multiple cases through from the very inception to the end. You've argued at hearings, and I think that kind of gave me the confidence. And I think in this particular case, it was an expedited arbitration where an award had to be rendered within 6 months from my appointment. And having had that experience, I just felt comfortable with accepting that appointment. I believe that had the right skill set.
Good. Now, the flip side, on your first day as arbitrator, what were you most nervous about?
Yeah, I'm not sure.
You don't have to be nervous. Maybe you weren't nervous at all.
I think I don't think there was anything to do with the procedure or the substance that made me nervous. I think the concern that we had, and I think this is a kind of a pre-arbitration, before I accepted my appointment, was the fact of that this arbitration had to be determined within 6 months, and I wanted to ensure that I had the requisite availability to deal with the matter, and I was very, very careful about that. I had to spend quite some time kind of looking through my diary before I did that. I think that was my only kind of initial concern, and but I think I was able to address that before I accepted the appointment.
Very good. Thank you very much, Manish. We're now going to move on to Sheila. Sheila, same round of questions. So when were you first introduced to arbitration?
Thanks, Nudra, and hi everyone. It's really great to be here. Thanks, SIAC, for the opportunity. Manish and I, he said we were ex-colleagues, so very happy times together, and we did have a number of things in common in that I first came into contact with the word arbitration and the practice and the concept also through the William Seeger's International Commercial Arbitration Moot. I was a postgraduate at the University of Hong Kong, and I was chosen to go and be part of the team arguing Overy in Vienna. And I was just delighted because I got one of those honorable mentions for oral advocacy. I thought, this is, great. But unlike Manish, and this has been a constant difference between him and I, that his decisions are usually very well thought through and mine are not. I came out of that and I did not practice arbitration. I just put it behind me and carried on as a trainee at ANO. And then I stumbled upon it accidentally while I was a litigation trainee, and I attended a seminar by Matt Gearing, QC, who is the global head of our practice and has been my mentor for many years. And I'll never admit it to him, but he has a lot to do with my inspiration for arbitration. I don't think he's joining today, so it's okay for me to say that. But I attended a seminar by him, and he really sort of took us as a group of trainees into what arbitration is about. And I found myself coming out and going straight to my desk and typing an email to HR saying, I know where I want to qualify. So that's how it sort of happened for me, quite disconnected from the real opportunity I got, but it came together very well eventually.
How interesting. Well, I would say in your defense, I don't know whether Manish has children or not, but the fact that maybe your trajectory of decision making will be a little more lateral than more straight. So how did you get to your first where you?
Sorry, I didn't hear that question, Nudra.
I said, so where did you, how did you get your first appointment? Where were you at the time and what stage of career were you at?
Yeah, so I was actually only a couple of years into practice, and I had an approach from a fellow arbitration colleague in the community in Hong Kong who approached me and said, I might appoint you as arbitrator, to which my response was, I haven't done this before, so you should really find someone else. And he sort of said, it's not quite how it works. And then I spoke to some colleagues and I realized that he was not joking and he really wanted to approach me. I was a little bit concerned because I didn't feel I'd had enough years sort of in practice, but actually the problem went away very quickly because my firm was conflicted and I couldn't act. But the following year, when I then turned my mind to it a lot more and thought, actually, that was an interesting foresight. What would happen if I got approached and took it a bit more professionally by way of response? And then I had an approach from the HKIC, sorry, SIAC, the following year, but followed very quickly by a second approach from the SIAC. And I was able to accept both those appointments and was absolutely delighted to watch that sort of kick off.
By that time, you were confident about your skills as an arbitrator?
No, but I think I was confident in terms of being able to serve the parties. So taking the SIAC case, for instance, I had a Chinese party and an Indian party, and I felt that that played to my skill sets and cultural background really well, being obviously of Indian origin, but having grown up in Hong Kong. And actually, I then realized through taking the appointment that substantively, the issues that I was dealing with was actually not dissimilar to the counsel practice I'd had for a number of years, just looking at it from a different lens. So I think the confidence came with time and actually biting the bullet and getting into it and accepting it.
Very good. I'm now going to ask you to just feel any sense of humility you have and tell me that what do you think is the parties or why as an arbitrator?
Yeah, I mean, I'd like to say that they see a seasoned practitioner with copious amounts of experience, but I'm not sure how accurate that would be. And I've got a panel here who already proved me wrong just by being my fellow panelists. I think what they saw is probably somebody, albeit young as an arbitration practitioner, but having the experience and the will and the drive to make something of their practice. I guess coupled with credible experience by way of their own background. But I also think, dedication goes a long way. And I think you can do a lot of things to show dedication. Looking back, I realize now that, there were a number of things I did, which I sort of now recommend younger practitioners to do, because I think seeing that dedication and commitment really enables parties to sort of grow trust in you. And of course, the confidence comes with that. So I'd like to think that's what they saw.
And what are those things that you think you would recommend lawyers starting out?
Yeah, so I mean, I think two things in particular. One is not to be close-minded. I think opportunities can come from all directions. I mean, I got my first one from a friend I made in the arbitral community, who obviously saw a lot more in me than I saw in myself at the time. And I was very grateful for that sort of, I guess that push in the right direction, as it turns out. So don't be close-minded. Get out there, meet people, identify opportunities, and stay positive. There will be lots of rejections before something comes, and I guess it just teaches you to value it more, but it's also just the way these things work. And the second thing I would say is, and I really do firmly believe this, is don't compromise substance for form. I think being active in the community is really important, and building your profile is key. Otherwise, how will people think of nominating you? But when you do get any opportunity, be it counsel, arbitrator, secretary, really anything, from an institutional perspective as well, then keep your head down, focus on the task that has been given to you. Don't compromise on your standards, and really show people that the trust they had in you is well warranted. And I think that's really important to sort of to keep the success going. Initial opportunity is one thing, but then you've got to show people that they made the right choice. And I think the best way to do that is to not compromise substance over form.
So how much would you say your practice currently divides between being an arbitration lawyer and an arbitrator?
So because I have a fairly busy counsel practice, and I'm sure Manish and others probably have a similar take on this, but I try not to take as a personal rule more than 3 appointments at a time, and actually maybe 2 if it's say sole arbitrator. But so on the flip side, cases I would do up to 4 or 5 at a time, and again, intensively so. Of course, there'll be lots of other stuff trickling in the background, but that would be the balance. And in terms of time spent on it, it really depends on the phase of the arbitration, doesn't it? Whether as counsel or arbitrator. But at any one point in time, I do try to keep that sort of 30-70, that balance. And I've been able to do so far. Being able to say no is a really big part of that. And when you're really young and sort of looking for opportunities, it's very hard to say no. But that's where having mentors and stuff really helps, actually.
Lovely. Thank you so much, Sheila. That was very interesting perspective on your entry into arbitration. Moving on, Dr. Hwang. So now you came into arbitration from the bench. Is that correct? So what was your entry into the world of arbitration? Your microphone is.
Yes, sorry about that. It was actually after I came back from the bench in early at the beginning of 1993, because I've been away serving as a judicial commissioner for 1.5 years. And while I was on the bench, SIAC started life. So when I came back to my law firm, the managing partner suggested to me that it might be a good idea for me to get into this new field. So I took it seriously, and I enrolled for CIR fellowship courses, took that course, went to Paris, signed up for ICC courses, signed up for conferences, and got to know the people who were involved in international arbitration in Asia, and a few other things happened, and I eventually got my first appointment.
When you left the bench, sorry.
So I just want to emphasize that this is not always the way things are done for retiring judges. For example, in the UK, I don't think the retiring judges would descend to signing up for a CIR course. They would think that during their time on the bench, they had heard a number of cases involving arbitration, so they're familiar with the principles and they think they can pick it up as they go along. That may well be so, but there's still, there are some rules about arbitration which may not pop up in the courts, but govern the way in which arbitration, there's an ethos of arbitration which is different from the ethos of court hearings. And you can't just transplant yourself as a judge and run an arbitration the same way as you run a court case. So that was, I think, the point I just wanted to make.
So you would recommend that if there are judges who retire and then come into arbitration, that they should get some kind of qualification or academic course background before they sit as arbitrators?
I think you have to be a bit tactful with some of the judges. I helped out with SIAC, and what we used to do when there were judges coming off the bench and had indicated an interest in learning something about arbitration and felt that they perhaps should not be attending courses together with people of 20 years younger, and a large chunk of the syllabus might well be something that they were familiar with. So I think SIAC then crafted a customized course, and they call it an orientation course rather than a training course, especially for judges. And they might hold it even ad hoc for a single judge. But they did it for a few judges in the early days. And by now, the bench does actually have quite a good knowledge of arbitration. I mean, in my time when I started, we had, international arbitration simply had not started going in Singapore. So the High Court bench really had no experience of international arbitration.
So when did you get your first appointment as arbitrator?
Well, the first couple were false starts. So appointed, we did the case management conference, and then the case is settled. So the first real case I had probably was 3 or 4 years after, well, you had to get the structure going, but as it so happened, my first arbitration was a domestic arbitration under the Malaysian Arbitration Act. So I was appointed to hear an arbitration in Sabah, which is in East Malaysia, and not even in the capital of Kota Kinabalu, but in the secondary town of Sandakan. So it was a dispute about land, as is very commonly the case in East Malaysia. A lot of the disputes are about land. And I was sole arbitrator, and I was put up at a very nice hotel, and I thought I had a very nice room. And they said, so I said, where is the arbitration itself? They said, well, it's going to be in the same hotel. So you just go upstairs 1 floor and look for the presidential suite. So I realized that that was where the arbitration was being held. It's a very nice room, of course, as befits a presidential suite, and the lawyers were all there. And I sat down and I said, where is the claimant, or the representative of the claimant? They said, well, actually, he's in the bedroom. And it turned out that this hotel was actually owned by this magnate, and he had been resting in the bedroom before it was time for him to give evidence, because he was the first witness. And so we called him in, and leading counsel for the claimant, who had come in from Malaysia, from West Malaysia, from Kuala Lumpur, to represent him, then showed him his witness statement and said, do you recognize this as your witness statement? And there was silence. And he tried again, as is that your signature on page so-and-so? Again, silence. And he said, well, can you at least confirm that you are familiar with the contents of this document? And again, silence. And in those days, when I was sitting on the courts, we didn't have transcriptions as a matter of course, only for capital cases. So all our judges had to do handwritten notes of evidence. And then you make notes of what the witness says sometimes. And when you have a pause from a witness, we record it as pause. So after his first answer, it was pause. It's my notes. Second answer, it was long pause. And then third answer was very long pause. At which point I then said to the counsel, would you like to have an adjournment? Maybe your client's not feeling well. I think the counsel was completely flabbergasted because, however that witness statement was constructed, he obviously didn't have any idea that the witness itself would not, as the English barristers like to say, he didn't come up to proof. He just couldn't make it. And so there was obviously an application for an adjournment while things were, reconsidered and a lot of discussions. And somehow, I think we had to carry on with the case without him as a witness. So they had to reconstruct their case and get somebody else to swear the relevant, witness statement. And then we had to make trips to different parts of Malaysia with different hearings, which were split up. And you went on in this vein until eventually it settled.
It sounds like, I think it was because you were a judge, you had the wherewithal and the diplomacy to deal with it in a very polite manner to something that seemed like obvious witness coaching. Why was this witness so unable to speak? Was it because he was in the next room and didn't have a long enough journey to come to the place of arbitration? Or he just was coached?
No, I think he was just suffering from dementia. It was basically that. And somehow his team in East Malaysia who were preparing him for this seemed to think they could get away with him coming and at least uttering something, say that, yes, I confirm this is my witness statement. Now, how he was going to survive cross-examination, I have no idea.
That's so interesting. And so was there a culture at that time when you came into arbitration of a preference for retired judges? Like we see that in certain parts of the world, retired judges are always the favored option as arbitrators.
Yes, although there are some very seasoned arbitration counsel who would actually like to avoid retired judges because they think that the approach or the style of the retired judge may not be continued. I mean, if a judge has been known for one who didn't suffer fools gladly, for example, when he was a judge and was scold counsel, they might not be appointed when they came back into practice.
So what
practice as an arbitrator?
So what would you say that are the general skill sets or attributes that an arbitrator should have? Or the flip side, what should you not do or not be like as an arbitrator? Because being a judge can, as you say, can be both a handicap, but also a help.
Yes, I think being a judge helps you to achieve a certain sense of gravitas because you are used to it. On the other hand, being a judge, in a domestic setting, you can assume deference from counsel, right? It's in every national judge will be entitled to expect deference from his local counsel. International arbitration is quite different. A retired judge may come and then he's faced with counsel from another jurisdiction who have no idea of his background or his temperament or his capabilities because they've never been exposed to that judge. And they may have their own plan of action or their advocacy style, which the judge may find a little odd. And there may then be a little bit of friction while the two adjust to each other. or sometimes it's just that they may not be used to the to the cultural differences between two nationalities, and they just have. I think the retired judges, in fact, any arbitrator who is hearing counsel from another jurisdiction needs to be mentally prepared to not assume that that counsel will behave in the same way as the counsel that he or she normally has been hearing when they were sitting judges.
Thank you. That was very insightful and interesting approach coming in from being a judge and coming into the world of arbitration. Last but not least, we have Nair, who some of the top arbitration specialists in the world tell me is a sterling amongst sterling stars. So without putting any pressure on Pramod, please share with us, how did you enter the world of arbitration? Where were you? Were you a student? Were you already in practice? And what drew you to it? Microphone. Your microphone is off.
Sorry. I think interestingly enough, I entered law school in the year in which India enacted a new arbitration statute. So that was a clear break from the past. It was a progressive statute based on the answer trial model law. There was a lot of excitement about it. There were courses taught on arbitration as part of the civil litigation course, and I found that very fascinating. There was a very rich culture of mooting in the law school that I went to in India. And therefore, we participated in moots within the country, outside the country. And therefore, that was my first exposure to the jurisprudence of the Iran-US Claims Tribunal, for instance. I then went on to study at Cambridge. And the real reason why I wanted to go to Cambridge was to be Professor Crawford's student. And he taught a fantastic course on the settlement of international disputes, which had a big chunk of arbitration in it. That also happened to be the time when ICSID's docket was growing quite significantly. There were quite a few controversial decisions on annulment, for instance. And we were fortunate enough to learn from people who argued some of those cases or who decided those cases. We would often have somebody who would participate in a hearing the previous week and come and discuss some of the nuances of that particular case the following week, of course, without disclosing anything that was confidential, but at the level of principle. I was then fortunate to be selected as a Pegasus scholar, and I spent a few months in London working with barristers from 20 Essex Street. And that was my first exposure to an LCIA arbitration, for instance, and the hearing center, the IDRC. And I think for a young lawyer from India to have seen such impressive figures and to see some fantastic lawyers and arbitrators in practice at such close quarters was hugely inspiring. And I think from that day onwards, I think I was probably hooked to arbitration as a career.
And so how did you actually, where was your breakthrough? Did you join a law firm? Which country were you in? Were they specializing in arbitration?
So I did a fair bit of domestic arbitration in the first part of my career. I worked for a law firm in India, and I did a fair bit of domestic arbitration. I moved to London then. I spent some time with the Lauter Pack Center, and I was doing some research at that point in time, and I joined Herbert Smith shortly after. And that was my first exposure to a fair bit of international arbitration, both commercial arbitration as well as investment treaty arbitration.
I see. And the domestic arbitration you did in India, this was after you finished at Cambridge, you did your master's. Was that under the new law?
It was under the new law, and there was new jurisprudence being made every month, so to speak. So it was a very dynamic field. It was a field to which a lot of the younger lawyers naturally migrated to. And therefore, it was a climate of some excitement in the arbitration community in India. I don't think there was an arbitration bar at that time. There are some who believe that there isn't an arbitration bar in India even today, but that is probably changing. And I think, going forward, I think India will have a deep pool of both arbitration practitioners who act as counsel mainly, and also people who act as arbitrators.
So why did you then want to leave India? If it was so exciting at that time, why did you leave?
Well, I think mainly because a lot of arbitration practitioners at that point in time were very good at arbitration-related litigation, but most of their arbitration practice was domestic arbitration. Whereas for international arbitration, I think clients were more comfortable using foreign law firms or barristers based outside India. And I think in order to understand how international arbitration worked, it was probably essential at that time to work in a large arbitration practice. And I was extremely fortunate to have been recruited by a fantastic firm, Herbert Smith, at that time, and be given the opportunity to work on a wide variety of cases.
And so when did you make the leap from being counsel to your first appointment as arbitrator?
I'd like to believe I haven't made that leap. I still have my leg in two boats without trying to leap one way or the other. My first appointment as an arbitrator was when I was 32. I was probably leaving Herbert Smith, or thinking of leaving Herbert Smith at the time, and I was approached by a lawyer who I knew well in India. They had an arbitration that was seated in Hong Kong, and they asked if I would be okay with my name being put forward. I was chosen. I was not entirely sure why, but I was chosen as an arbitrator. I think quite interestingly, that was also my first and only documents-only arbitration. So there were 3 arbitrators, one based in Hong Kong, one based in Singapore, me in London. Subsequently, I moved back to India before the arbitration ended. And I think the arbitration worked very efficiently on a documents-only basis. There were no hearings, either in person or virtual hearings. And the entire arbitration was concluded in around 9 or 10 months, which was quite an achievement considering the fact that quite a few of the documents were in Chinese. They had to be translated. The 2 members of the tribunal were not conversant with Chinese. So there were those challenges, but despite that, I think it was a great experience. It was a great experience to also be working with 2 other very well-known arbitrators.
Is that a common thing? Have you had a number of arbitrations like that, which are just documents only?
It's not often the case. I think probably because the sums in dispute in that was probably less than 5 million. And I think parties wanted to keep costs low. The tribunal gently asked the question as to whether the parties would like to have a physical hearing or a documents-only arbitration. And I think both parties were quite comfortable with having a documents-only proceeding.
Now, I'm going to ask you that tricky question, although you've already preempted it and said you don't know why they chose you, but why objectively do you think they chose you? What did you represent that made it attractive for the counsel in that arbitration to appoint you as arbitrator?
Well, I think in many ways that was because before the world knew Sheila and Manish and a lot of other arbitrators who probably had some sort of Indian background, but at the same time were quite conversant with how arbitration is practiced internationally. So I think what the client was probably looking for, or probably the client's lawyers were looking for, because at the end of the day, my sense is that lawyers and arbitration institutions are the most important gatekeepers for arbitrator appointments. And if those are the constituencies who ultimately make the appointments, what they would look for are people who have the expertise in a particular system of law or understand a particular culture well, and at the same time have the international exposure and approach, which is absolutely essential for deciding some of these disputes.
So would you add?
Probably they thought that I ticked some of these boxes.
I'm sure others also. Yes. Would you advocate to lawyers or practitioners who want to become arbitrators to travel and try to broaden their experience base or their understanding of culture base?
I think that's absolutely essential. It's essentially in the practice of international arbitration. I think it's absolutely important for common lawyers like me to have at least some sort of familiarity, working knowledge of the civil law system and how, for example, arbitrations are held in the civil law world, because contracts are often entered into between parties from the common law systems with counterparties who are from the civil law tradition. And therefore, it is that amalgam of cultures which makes international arbitration so exciting and so vibrant. So I think the greater opportunities that people have to practice internationally, work on a wide variety of cases, not in a sense restrict themselves to a particular domain area, for example, shipping or intellectual property, but have, at least in the early years of their practice, as broad-based a spectrum of cases that they work on, etc., usually provide a good foundation then to specialize as an arbitrator, or, once you have some mileage under your belt.
Thank you very much. This is a lot of other questions have arisen from your introductions. Thank you for that. This was the end of our first segment. I don't have a hamper. I couldn't give it to you even if I had one. But all of you, I let the audience decide who was most interesting, but all of you have very, very interesting and diverse perspectives. We'll now move into the second segment, which are general questions, the kinds of questions that are floated around a lot by practitioners who are interested to become arbitrators. I think one of the most commonly asked questions is, what is a good age to become an arbitrator? So Pramod, you said you were 32, which is quite young. Dr. Hwang came after he left the bench. I assume this approach of focusing on age may have developed, I may be wrong, from the parallel of becoming judges, because in a number of countries, becoming a judge is regulated by age. But I wonder if it's a good narrative to put so much focus on age. Should we put an age on when you should become an arbitrator or not? Let me throw it out to Sheila first.
I think absolutely not, Nudra, and for the first very simple reason that women will simply never answer that question. So it won't be a fair one anyway. But actually, just let's just and more realistically, I actually do think that you're right that historically people did focus on that as a measure of experience. And the closer you are comparable to, getting on the bench, that means, if I choose a parallel route, I want someone just as experienced. But actually, I think together with, the way times are changing, age can mean different things to different people. Some people actually would prefer a different age bracket of an arbitrator who actually understood them more, or some people would simply not even turn their mind to it. I think there's so much more to focus on in terms of what an arbitrator needs to bring to the table, that age, so far as I'm concerned, if I ever had a discussion with anyone, which we do tend to do a lot about who would be the right person for it, we've almost never looked at, and how old is this person? I think it's a different matter when obviously somebody cites their own age as a concern, depending on how long a matter might run, and they feel, they don't want to commit to something for so long. That's different. But I think the presumption should be that there's enough other substantive factors, and age is simply a fading out concept in my view in terms of consideration.
Your point about this whole, I'd say, a group of, people which are women, it would be very difficult. And now there is so much of a focus, not a focus, I'd say there's more of a appreciation and recognition of like panels not being manels, as happened recently in one of the arbitration conferences, where they had a great difficulty because they couldn't find a woman to put on the panel, and then they were faced with criticism by the audience who said, why was this a manel? And it should have had some women also in it. And for women, a number of women who will be in our audience also will appreciate that our trajectories often are different because of motherhood or marriage, etc. But a number, increasingly, I find, certainly in Pakistan and in England, I also saw that women would take time out longer than their usual maternity leaves and then want to come back into the practice. And so for that reason also, it is important to be able to widen the field enough to allow entry at any age. So Dr. Hwang, then what should the focus be on? If it's not age, and what should we really focus on more?
If we are looking at the Singapore context, the advantage of Singapore for development of younger arbitrators is that we have a thriving arbitration center with a rather large caseload by international standards. So therefore, the institution has the opportunity to offer appointments to people who would otherwise not be appointed by parties. So the reality is that it would be relatively unusual for young arbitration practitioners of between 30 and 35, let's say, to be appointed by party, choosing them as party appointed arbitrators, because the client will tend to insist you must get somebody very experienced to put on as our party nominated arbitrator. Now, let's just look at SIAC as an example, and I think this example is also followed in other major international arbitration centers. SIAC has a main list for arbitrators who have to qualify in terms of objective requirements of seniority and experience and so on. But they also have an unpublished reserve list, and the SIAC then mark out promising young arbitration practitioners whom they get to know either from cases that these young arbitration practitioners are involved, because very often the younger lawyers in a team will be the ones corresponding with the institution and the other parties. So they get to know the counsel in SIAC. And then for those in other centers, other countries which have mature arbitration centers, all of these international arbitration centers have a youth wing, as it were, called by something different, usually young SIAC, young LCIA, young ICC, and so on, even young ICA. And the younger arbitration practitioners can get involved in that organization, which runs then seminars and other activities for their own members, and they also interact with SIAC that way. So SIAC become aware of this group of younger practitioners and who may or may not have served as tribunal secretaries, which is another important step in acquiring knowledge and experience. And then they will give them appointments. And I actually polled my former associates who are still working in arbitration firms, and their experience has been quite common. They get their first appointments when somewhere around about 31, 32, 33. And then if they do okay, then they may get similar appointments. These appointments will always be sole arbitrators, as I said, because of the difficulty of parties appointing them. But where they are the smaller cases and the SIAC has the opportunity to appoint, then they will try and look and give experience to the younger ones for lower value cases. And then SIAC will provide secretariat backup and assistance both at the administration level as well as when it comes to scrutinizing the award, because SIAC is one of the few institutions, along with ICC, which has serious scrutiny of awards. And so the senior counsel in SIAC can help the junior counsel, junior arbitrators in getting the award right and in accordance with their requirements. So that's the sort of way that these things progress. And if you adapt it for other countries, then they can also do this in other countries. If they happen to be like in India, where there is no strong institution except Mumbai, which is growing slowly, then there are international youth wings that can be, they can tap into, typically young ICA or I'm just trying to think of truly international institutions which have you.
Well, it's what you're saying is that's great for where there are institutions, but what would you say, Pramod? What do you do in countries where there aren't institutions? And how would you then, as a young arbitrator or a first-time arbitrator of any age, how would you then get into the field? Because every country doesn't have these kinds of well-oiled machine systems which make it easy for arbitrators to flourish.
I think, thankfully, in many ways, most of the leading arbitration institutions are truly international. So when they consider candidates for possible appointment as an arbitrator, their pool of candidates is not necessarily restricted to people who are probably based within the headquarters of that arbitral institution. There are also, for example, ICC or SIAC arbitration seated in India. So therefore, a good Indian arbitrator who's developed a good profile in arbitration would certainly be on the radar for these institutions for appointment. And I think that's very important. The other aspect, which I think is quite crucial, is that it would be helpful for young arbitration professionals to not only be visible at conferences and proactively participate in them. I think it's quite important to also show that you have the ability to analyze important issues and write on them. And I think it is this kind of impact writing which make people sit up and take notice. I mean, it need not be, for example, a case comment, but if you have somebody who writes an article which is quite crucial and path-breaking in its field, something along the lines of Jan Paulsen's Arbitration Without Privity, or for the fact that someone like Professor Hannah Shio has specialized in this area of complex multi-party, multi-contract arbitration. So I think if you pick a field which is likely or poised to grow, and you specialize in that early, and you demonstrate some thought leadership in that area, you would almost inevitably, create a profile for yourself, which would land you then, at least in a short list of possible candidates for appointment going forward.
That's very true and echoed by a number of practitioners. So building links with institutions, Manish, other than writing is an established good way, what happens if, one, how do you build links with institutions if you want to become an arbitrator? Number two, do you think it is going to be different now with the new normal? Is it going to be easier or not? Because in one respect, it's easier to now build up your profile through Zoom, but harder because you haven't had physical connection or contact. And in order to choose an arbitrator, there's so many factors. So what would you say would help in building links?
Thanks, Nudra. I think in terms of building links with an institution, as Pramod mentioned, kind of showing a real expertise through various kind of profile building activities, in your own practice as counsel or whatever role you're performing. He talked about thought leadership in terms of writing, impact writing, speaking at conferences, teaching, often helps, where you're able to contribute to academia. Ours is one field where there is still a very close collaboration between academia and practitioners. And I think teaching helps. Participating in events like ours, interacting in workshops, helps. And most of the institutions are always looking for volunteers for various kind of conferences and seminars, and putting your hand up at an early stage, making your presence felt is quite important. I think in terms of the impact of COVID and whether it facilitates or actually obstructs, in some ways it is quite liberating as well. I know all of us, or most of us, may be suffering from a Zoom fatigue, but I think what it has done is it has obliterated boundaries. It has removed barriers to participation in important events across the globe, which would have required you to physically travel to a certain jurisdiction at significant costs. And of course, for sometimes younger lawyers, it can be difficult to, either fund the thing yourself or to procure the funding from your institutions, because quite often you're not able to justify that participation unless, of course, you have a speaking role, right? But I would believe that webinars have actually facilitated that access to know-how and people with expertise that may previously not have been possible. And I think, of course, there's a balance to be struck, and and I think it's left to each individual to do that. But I actually see the remote format, kind of maintaining a presence even post-COVID, hopefully, and I think that can only be a good thing for a profession like arbitrations.
Certainly a good thing for a profession like us lawyers, who are very good at monopolizing lots of fields, which brings me to the last question that I'm going to throw out and start with Sheila, and it deals also with a question that somebody has asked, which is non-law practitioners. What is your advice for people who want to come into arbitration, who want to be arbitrators but are not lawyers? Because lawyers do tend to take over. Like now, we also have a new field of mediation, and that's been interesting because I feel there's a pressure on lawyers who feel we need to reinvent ourselves as mediators now. So what is your advice for any non-law practitioner wanting to become an arbitrator?
I think it's similar to what Pramod was saying about building your sort of credibility by either writing or picking an area that you can be solid at and contribute. If you're a non-lawyer and you want to be an arbitrator, first of all, there is a lot of room for that. I've seen increasingly actually clients take decisions where actually having the combination in a 3-member, more likely, tribunal, where there'll be usually either a senior junior lawyer together with a non-lawyer, and then there's this sort of perfect mix of different balances. And what the non-lawyer brings to the table actually is the expertise. So really identifying that expertise, and then I think using the tips that this panel has shared about profile building, but not trying to become a lawyer. So one of the questions helpfully about our arbitration course is good. I think they're good to the extent of practical courses of how am I actually going to play the role of an arbitrator. But I think if you're the non-lawyer, don't try and sort of dip your toe into the trying to be the lawyer, because by and large, I think you'll be in a combined panel where other people do bring that. And I think you focus on what you bring, really hone it, profile it, and then nail it, is what I would say.
Thank you very much. We have 1 minute left, and I just thought of one last thing, which is that I want one word from each one of you on the last word you want to give to aspiring arbitrators. Just one word. So starting alphabetically, Manish. Advice of one word to aspiring arbitrators. Or let's say one sentence. One word is difficult.
If it was 2 words, it's integrity and brand.
Thank you. Sheila.
Can I say 2 words as well? Confidence and perseverance.
Confidence, very good. Dr. Hwang.
Empathy. Empathy, especially in cross-cultural contexts.
Pramod.
To adapt to counsel from different jurisdictions.
Thank you. Pramod?
My one word would be industry. I don't think there's any substitute for hard work in arbitration, as with most things in life.
Fantastic. That really just, I think all those words together really summed up everything. Our time is up. Thank you to the panelists. That was very insightful. And thank you to the audience for listening. I hope it was useful for you. And I hope one day when you're all seasoned arbitrators, you will look back and give some credit to our sterling panel. Thank you very much and goodbye.
Thanks so much.
Thank you. Thank you.